of the Labour Act correspond to the constitutional guarantee of the right to access the courts under Section 69 of the Constitution, if it does?
Thank you, Chief Justice. May I please ask for you to repeat the question?
How does the compulsory arbitration mechanism in Section 93, subsection 5, subparagraph A and C of the Labour Act correspond to the constitutional guarantee of the right to access the courts under Section 69 of the Constitution, if it does?
Thank you, Chief Justice. Yes, indeed, the provisions in Section 93, subsection 5, indeed guarantee the right to access to courts as provided for in Section 65. As that section provides for the referral of a matter to compulsory arbitration if there has been issued a certificate of no settlement by an arbitrate, by a labor officer, if the parties have failed to agree during conciliation. And and subsection A will be dealing with disputes of interests, and subsection C will be dealing with disputes of rights. So this subsection 95 will allow the dispute to be ventilated through the compulsory arbitration mechanisms, which mechanism will entail the parties' right to be heard and to present their cases.
Yes. You may switch off your mic. The second question is as follows. How would you distinguish between a question of law and a question of fact in determining the grounds for an intended appeal from the Labour Court, and what implications would this distinction have on the intended appeals prospects of success?
Thank you. The definition of a point of law were laid out in the case of Musua and versus United Bottlers, where it was held that a question of law is an issue. It's a question which seeks to answer a certain legal issue or inquiry, and the answer in that, in the answer of that question, the judiciary has no discretion to make any determination which is outside the answer which is provided to a question of law. And also, a question of law is the area within which province a jury or assessors have no jurisdiction, but the judicial officers have discretion if it's a question of law. And a question of law is also it's also, in terms of that case I've highlighted, it's an inquiry which seeks to determine a certain legal issue or to answer a certain legal inquiry. Then the question of fact is usually on the issues or factual matters which were raised in a determination, in a case, and does not involve the judicial discretion, but the inquiry of assessors. So this distinction will determine whether or not a matter will proceed to appeal to the Supreme Court, because it has to be a question of law only that has to be referred to the Supreme Court. So if there is no question of law, the matter will then not pass as deserving to go for appeal to the Supreme Court. However, there are instances whereby there are gross misunderstanding of facts by the judiciary, by the judiciary in the court, and such a departure from the facts, or a gross misunderstanding of facts which is inconsistent with principles of logic, that particular issue becomes a question of law. Thank you, Chief Justice.
The third and last question is as follows. Does the right of an employer to commence disciplinary proceedings against an employee prescribe? Justify your answer.
Thank you, Chief Justice. Yes, in terms of the Labour Act, it prescribes in as far as a referral to the Labour officer is concerned. If that matter has to be referred to a Labour officer, it has to be done within 2 years since a party to that dispute became aware of that knowledge. So in that instance, that right will be said to have prescribed. But the only exception is that if the right is continuing at the time the claim is made, one cannot then raise the issue of prescription of that right. Thank you.
Thank you. I'll now hand you over to the other commissioners for further questions, if they have. Yes.
Thank you, Honorable CJ. Good afternoon, Ms. Sar.
Good afternoon, DCJ.
I have one question for you. I might have another one later on. And the question goes as follows. Having regard to the provisions of Section 176 of the Constitution, Section 176 of the Constitution, how do the powers of the Labour Court differ from those of the High Court?
Thank you, DCJ. Section 176 confers inherent jurisdiction on the High Court. So they differ in the sense that the Labour Court has no inherent powers in its jurisdiction. It has powers which are governed strictly by Section 89, subsection 1, and is corroborated by Section 89, subsection 6, and it cannot go beyond those powers, whereas the High Court has powers to formulate its own processes and procedures. Thank you, DCJ.
So you're saying the Labour Court does not have that same power to regulate?
The Labour Court has same powers with the High Court when it comes to issues of
I'm
refuse.
talking about regulating its processes. You said the High Court has that power. What about the Labour Court?
Inherent, in as far as inherent jurisdiction is concerned.
Thank you.
Yes, thank you.
Thank you, Honorable Chief Justice, and good afternoon.
Good afternoon.
Right, you were employed as a magistrate at one time?
Yes, thank you, Attorney General. Yes, I was employed as a trainee magistrate by the JSC.
Yes, and do you agree that you were discharged from that office because of abscondment?
Okay, if I may explain that the issue which arose, Attorney General, was that at that particular moment I was assigned to Gweru Magistrate Court. After being sworn in, I was assigned to Gweru Magistrate Court.
Sorry,
Yes.
just to save time, I think we are all agreed that you were discharged because of abscondment, and particularly for having not reported for duty for a period in excess of 30 days. Wasn't that the case?
In that matter, I would like to explain, Attorney General, if you may allow me. I was assigned to Gweru, and I was asking for the indulgence of during that period where I was not attending, I was asking for the indulgence of the JSC so that I can be placed in Harare. As at that time, I had a small baby who was having some health issues, and I was asking for some indulgences. And then during that process, then I was then terminated.
Sir, you agree that abscondment is not an attribute of integrity, particularly judicial integrity? Yes, abscondment is not an attribute of integrity.
It was historical. Yes, I admit, Attorney General, but that is historical. I have now matured, and the circumstances which resulted in that have since changed. My child is now grown and has grown out of the medical problem that was causing it impossible for me to work in Gweru.
You regret, however?
Yes, I absolutely regret that scenario indeed.
Okay. No other questions, Chief Justice.
Thank you, Chief Justice. Good afternoon, Ms. Hale.
Good afternoon, Commissioner.
I have one question for you, which is split into two, right? And this is the question. What is the effect of, one, an appeal to the Labour Court on the determination or decision being appealed against, right? And two, what is the effect of an appeal to the Supreme Court on a Labour Court judgment or order?
Okay, an appeal to the Labour Court does not suspend. An appeal to the Labour Court does not suspend the operation of the judgment being appealed against, and an appeal to the Supreme Court has an effect of suspending the decision being appealed against, because the Labour Act does not provide that the decision to an appeal to the Supreme Court suspends the ruling. So the common law position applies.
Thank you, Ms. Allen. Thank you, Chief Justice.
Yes. Thank you, Chief Justice. Good afternoon, Ms. Allen.
Good afternoon, Commissioner.
I have one question for you. Depending on how you answer the first part, the question is the second part. Can a judgment of the Labour Court be executed or implemented pending appeal to the Supreme Court? And if your answer to that question is in the affirmative, under what circumstances?
The matter of an appeal pending from the Labour Court to the Supreme Court cannot be executed because of the answer I've previously given, that in appeal to the Supreme Court, it suspends the decision being appealed against. So that means that it cannot be executed as it would have been suspended. However, a party can apply for execution pending appeal. So if that is granted, then the judgment can then become executable.
Thank you, Chief Justice.
Thank you, CJ. Good afternoon.
Good afternoon, JP.
Yes, I've got one question for you. What factors does the Labour Court consider in the assessment of damages in cases of unlawful dismissal?
Okay, thank you very much, JP. The Labour Court, it factors in whether or not a party would have mitigated its losses. So mitigation of losses entails what was mentioned in the case of Ambali versus Butter Shoe Company, wherein it was held that after being unlawfully terminated, an employee has a right to mitigate his or her losses by looking for alternative employment, and if they cannot prove that they made that effort to get alternative employment, then they will only be restituted up to the period where it is reasonably believed that they could have secured alternative employment. And the court will factor in issues like the nature of the qualifications that the employee have. They would also factor in the economic environment, whether or not it is easy for one to get employment in the prevailing economic situations. However, the court yes, those are the factors they will consider whether or not they mitigated. And in its determination, evidence has to be led, evidence has to be adduced so that the court can come to a decision on the just and appropriate damages in a particular case. There are various cases whereby it was the Supreme Court had to remit matters back to the Labour Court, wherein the Labour Court had not sought or have evidence in the making of their judgment, where it appeared the Labour Court had thumbsucked some figures. So it is crucial that some evidence has to be led and that mitigation has to have occurred.
Thank you.
Thank you. Good afternoon.
Good afternoon,
Miss
Commissioner.
or Mrs. Hare?
Mrs. Hare, thank you.
Mrs. Hare, good afternoon.
Thank you.
Please, can you walk us through cases where there can be lawful limits imposed on the right of employees in Zimbabwe to form, join, and participate in the activities of trade unions and employers' organizations of their choice?
Thank you, Commissioner. I'll start from the background of this right to join, where it arises, this right to join trade unions of choice. This is a constitutionally provided for right in terms of Section 65 of the Constitution. The lawful limits, which I can think of in the there are therefore no lawful limits. There are lawful limits when you are a member of the security forces in terms of the Constitution. Then you cannot be ascribed to a trade union or a workers' organization. Thank you, Commissioner. That is the limit.
What about beyond the members of the security services? Are they lawful limits that can be imposed on them?
Yeah, lawful limits on joining the trade, there are no other I can think of, unless it was the right to strike, maybe then I would say it would be limited for essential services. Those in the essential services, they'll be restricted.
All right, thank you very much.
Thank you, Honorable Chief Justice. Good afternoon, Mrs. Hay.
Good afternoon, Commissioner.
I have one question, which is coming in two parts. What are the limitations regarding the Labour Court's authority to rescind or vary its own orders upon application by either party.
Sorry, may you please repeat the last part? You said, what is the limitation of the Labour Court with regard to its...
Authority to rescind or vary its own orders upon application by either party.
Okay. Okay, the
Then
limitation...
the second part,
Okay.
does such an application stay the execution of the pre-existing court order?
Okay. The limitation regarding the authority to vary its own orders arises in issues where the matter has already, where the matter has been referred to review. In that instance, the Labour Court cannot vary its decision, and it is in the court's discretion whether or not to grant an application for stay of execution in rescission of default judgments. Thank you. That will be my answer.
Okay, thank you, Honorable Chief Justice.
Thank you, Chief Justice. Good afternoon, ma'am.
Afternoon, ma'am.
I have a couple of questions for you. The first one is, can you explain this discrepancy between your CV and your questionnaire?
Thank you, Commissioner. I indeed admit that there are discrepancies on my experience in the law practices. There was an inadvertent action on my part, I admit, due to the exigencies and experiences required where I was. I had to tailor-make the CV so that it suits the current experiences that I have, whereby it was not very much important for me to have practiced in private practice.
What do you mean it was not very much important for you to have practiced in private practice?
I mean that for that particular job that I was applying for, the need was for corporate experience. So I had omitted my experience in private practice. However, it was not due to some bad records or anything. My records is...
Why did you give us that CV?
Sorry?
Why did you give us that CV?
That was inadvertent, as I have admitted, Commissioner, on my part. So I attempted to correct that on the questionnaire, which I believed was the second bite of the cherry for me to bring out issues in the open.
But you want to be a judge, and judges can't afford to do things like that. You always must be accurate. You are giving the wrong impression in giving us. It means you are not serious about this application. You just pulled a CV that you did for somebody else a long time ago and just sent it to us, and we're supposed to take you seriously?
I am very serious about this appointment as Commissioner. That is why I went the extra mile of even explaining in my questionnaire and even fulfilling all the requirements for going for a medical examination and attending this interview, and my sincere apology for that.
Now, in your CV, you claim that you were a Zimbabwe and associates when we have you on record as having been our employee at that time. So in your CV, you claim to have been at Zimbabwe and Associates when we have you on record as having been our employee at that time. Can you explain that?
My apologies. That would have been an error on my part, but I was indeed at CINEMA, and I was indeed part of the Judicial Service Commission, Commissioner.
Looking at your questionnaire here and what you have written, I then moved to Harare from January 2012 to November 2013. I joined Chingeya Manditsira Masawi and Partners. It is there that I built my courtroom experience and legal consultancy for both corporate and individual clientele. The first problem is you write as if there is a firm called Chingeya Manditsira Masawi and Partners. Are those not three different firms?
Those are different types. Chingeya Mandisira is another law firm, and Masawe and Partners is another law firm. That will be a punctuation error, Commissioner.
And you worked for those 3 law firms between January 2012 and November 2013. That was not even 2 years in total, 3 different law firms. And you claim that you built courtroom experience in that period of time.
Yes, I built experience in as far as the workload that I got during that period was very intensive. And I managed also to ameliorate my experience by being employed by other legal practices. As you will see that I then go on, I went to Chipato and...
No, that's
senior.
fine. I'm going by what you wrote here. You say in that period of about 20 months, you built your courtroom experience between 2012 and November 2013. It's important because when you want to be a judge, you don't generalize, you don't embellish, you don't decorate, you present facts as they were. You do not build courtroom experience in less than 2 years. But let me go on to the next paragraph of your write-up. You then say in December 2013, you joined the JSC as a trainee magistrate. And initially, you sat in as a magistrate. Then the second part of the training entailed being a judge's assistant at the High Court. Then I want to read this. I then did not pursue a further role as a magistrate, as I had been exposed to the greater heights of the superior courts as a judge's assistant at the High Court. Is this correct?
That is partly correct, and the other reason that I have mentioned earlier on.
I have a problem here because you were a judge's assistant and then you became employed as a magistrate in November. The following year in July, when you were posted to this position which you could not take for personal reasons you've explained, that's how you ceased to be a magistrate. So how can it be correct that you did not pursue being a magistrate because you had tasted being an assistant, when in fact you were a magistrate after being a judge's assistant and your contract was prematurely terminated? Is this presentation you've put here correct?
Commissioner, I never had occasion to sit in as a magistrate because the issues that I've alluded to earlier on arose as soon as I was sworn in, so I never had occasion to sit in as a magistrate.
What were you doing from November of 2014 to June 2015?
I then joined a company, Shine Plus Private Limited, where I was the legal advisor.
Because according to what I see here, you were employed as a magistrate in November, and then the following year in July when you were being transferred to Gweru, that's when your contract was terminated. But anyhow, the next thing I want to go to, you then say you moved to Shine Plus Private Limited as a legal advisor, and this is where your passion for superior court advocacy was awakened. And then after that, you went to Linda Chipato and Attorneys, and then to Sinemo and Associates. And at Sinemo and Associates, this is where your passion for labor law was awakened. I'm reading what you wrote here. But having had your passion for superior courts and your passion for labor law being awakened, you did not stay in legal practice. You then moved to the Forestry Commission. Now, the impression I have here is that you were polishing up to impress us, and polishing up without fact, inaccurately, and it does not impress, especially for somebody who wants an office of utmost integrity. What is your comment?
My comment is that, Commissioner, I was not polishing up, but indeed I had occasion to practice in Sinemo and Associates, where I was assigned with most of the labor cases. Even if you can check on the cases that I attended to, there are some labor cases there. However, most of them were still
I have no issue with that. My issue, you say my passion for superior courts was awakened. My passion for labor law was awakened. And then you promptly leave legal practice and go to corporate as a company secretary. But we are supposed to be impressed that you've been wanting to be a labor court judge for so many years. That's where I talk of polishing.
Even at Forestry Commission, Commissioner, I have occasion to be at the center of labor relations, as I highlighted there as well. I also have external liaison with external lawyers who will be attending to matters in the Supreme Court. I'm the instructing attorney, and the success or failure of those matters I'll be instructing on depends on the probity of the instruction that I'll be giving. And I also lead the Works Council meetings in Forestry Commission and labor relations disputes, collective bargaining matters at Works Council. So it is indeed true that I have a passion for superior courts, but there could be some circumstances that made me to prematurely leave the legal practice so that I could be economically enhanced as well whilst pursuing my passions. Thank you.
Thank you, Chief Justice. I have no further questions.
Yes, thank you, Chief Justice. Good afternoon.
Good afternoon, Commissioner.
Yes, I want to follow up a little bit more on the questions that Commissioner Moyo was raising. Right. She stated that, you know, the way you're presenting in your CV, in your questionnaire, if we're not polishing up, you know, to impress us, my take is that you have a problem with writing. And expression is something that is also clearly coming out. You did not do well in the written examination, the written part of this interview. The comment I have here is that for your writing skills, right, the candidate's grammar, presentation, and structure were below average, earning 3 out of 10 marks in this area. I will not comment on the other areas that you did not do as well in terms of knowledge of labor law as well as procedure, but I'm just focusing on your writing skills. It seems to me you have a problem with writing, and my question therefore is, how will you be able to write judgments as a labor court judge, judgments that will be able to communicate your decisions as a judge?
Thank you, Commissioner. I would like to explain that poor performance on the pressure and pressure that was occasioned by the initial exam. We had to access the ECMs, and my experience right now, as I have indicated, is in the corporate sector, where I have limited access to the ECMs. However, I would like to say that if I'm given a chance to be a judge, I would make use of the training that the JSC offers to its officers, and I would also work on my writing skills in terms of the principle of collegiality, whereby I'll be seeking mentorship and getting some ample time to research on matters that test was in a situation of extreme pressure. That is why I felt, Commissioner.
But we can't teach you to write. Judgment writing is a core skill for a judge. We can't really be. I'm not too sure the amount of training that you would require for you then to be able to get to the level that we're looking at, given the examples that were being given to you by Commissioner Moyo, given also what is clearly coming out of the examination part that you took. I still have problems that training alone will not cure the challenges that you have in writing.
That judge was just a result of the pressure, extreme pressure that I was in, and also challenges I was having with my gadget. I'm sure when I am in a less pressure for environment, I'll be able to fare in very well.
And I can assure you there's more pressure ahead. Thank you, Chief Justice. No further questions.
Few questions. When did you prepare this curriculum vitae, CV?
I prepared the curriculum vitae when I was applying for employment where I am currently.
Where you what?
Where I am currently working.
So you were preparing it for
Corporate.
potential employer, corporate.
Yes,
For-
sir, Sujay.
That is for the. So you intended them to use this CV to employ you.
Yes, they employed me, yes.
They employed you.
Yes.
So you know they employed on falsehood.
That was not the intended purpose.
Sorry?
That was not the intended purpose to mislead, because the
they employed
experience
you
I
on-
have.
Yes, it doesn't matter what is we don't know what your intention is, but except what is apparent from this document. You lied to those employers, isn't it?
I wouldn't exactly put it like that, CJ.
Sorry?
I wouldn't want to put it like that, but
you
indeed
gave
that was
them a
not the truth.
CV that was not telling you the truth of itself. For example, it says you were employed by this firm, Nema and Associates, way back
I was employed.
when you were still employed as a magistrate. You are saying to this employer you were employed by this
There
firm,
was-
when you were in fact employed by as a magistrate.
The periods are the ones which are varying, but it is indeed true that I was employed there. But
That
the
was not
periods-
correct, isn't it?
The periods.
In
yes.
your CV, that was not correct.
Yes, the period, yes.
Right. Now, you also said in this CV that you got employed at Forest Commission from August 2016 to current. Was that correct?
I was employed from 2019 to current.
Yeah, but here it says Forest Commission August 2016 to current.
That was inadvertent, and I've admitted that, Chief Justice.
But that's what it is, isn't it? It says that. We are not reading from nowhere.
Yes.
Then you then told this prospective employer that you were employed by Nema and Associates from August 2014 to July 2016. That is not true, is it?
It's not.
It was not true.
Yeah, it's not true.
It's not true.
Yes.
But what do you make of that employer's misrepresentation? This person, whoever employed you on this CV, was misled, isn't it? Was misinformed. There was this CV was not correct.
That is what the effects are, yes.
Yeah. Now you know that attention to detail and accuracy is an attribute. It's an inherent attribute of a judicial officer. Do you accept that?
I accept that, Chief Justice, yes.
Yeah. So what do you make of this lack of attention to detail? You seem to just give wrong information.
That is why I say that I apologize for that, and that can be rectified when I'm in a. That can be rectified, yes, by giving true information.
We rectify it now for purpose of you becoming a judge.
I indicated on my question, Chief Justice, that it was an inadvertent misdirection on my part.
Why did you give us the papers that are not correct?
think it was, it was the excitement of the nomination and also
All right.
inadvertence.
Excitement, is it? All right, thank you.
Yes, yes, Mrs. Sir, just one question. So you are conceding that you included wrong information in your CV?
I've considered that, yes,
And that,
DCJ.
because the position we now have before us and the papers that we have before us shows substantial inconsistencies, especially insofar as the dates you claim to have been at NEMA are concerned, and also insofar as what perusal of your personal JSC file brought up, the stark contrast in terms of dates. So you concede that you provided misleading information, in fact, untruthful information. Does that not go, in your view, does that not go to the integrity, to your integrity?
I had, when I was doing my questionnaire, I thought I was curing the discrepancies in my CV in as far as my experience in law practice can be verified from the Law Society that indeed I was a practicing attorney, DCJ. So I thought my correction in the questionnaire would suffice to cure this flagrant misfact.
Because without an explanatory note to say, please note that the inconsistencies in my CV are corrected by the information in the questionnaire. At least to say that, so that we would know, so that we would not be asking these questions if you had done that. But we're left with a situation where there are such big inconsistencies that seem to point towards a lack of integrity on your part, and integrity is very integral to the work of a judge.
Yes, I concede to that fact, DCJ. And I've explained that I thought that my questionnaire was going to cure that, and the fact that we record with the Law Society speaks for itself.
We've covered that, I think.
Yes.
We've covered that enough. Thank you.
Yes, thank you. We have come to the end of your interview. You are excused.
Thank you, Chief Justice.
Thank you. Yes, we just confirm we have Hove Thompson. Yes, fine. As I indicated this morning, I will ask you 3 questions. The first question is as follows. How does the compulsory arbitration mechanism in section 93, subsection 5, subparagraph A and C of the Labor Law, of the Labor Act, correspond to the constitutional guarantee of the right to access the courts under section 69 of the Constitution, if it does?
If I may ask the question to be repeated, Chief Justice.
Sorry?
I beg leave that the question be repeated.
If you can speak up. You want me to repeat the question?
Yes.
All right. How does the compulsory arbitration mechanism in section 93, subsection 5, subparagraph A and C of the Labor Act correspond to the constitutional guarantee of the right to access the courts under section 69 of the Constitution, if it does?
Thank you, Chief Justice. Compulsory arbitration is carried out in a situation where there is a dispute of interest and the parties involved are in the essential services. So, in a situation whereby it's a dispute of interest, it doesn't have, there are no established legal rights and obligations, but it's creation of new rights. So, usually access to courts is for disputes of rights where there are already legal entitlements, and the issue will be on maybe interpretation or the validity of those rights. So, in my view, compulsory arbitration, insofar as it pertains to dispute of interest, the recourse does not lie with the court, because, as I have already explained, it's only dispute of rights that have got defined legal interests. They are already there. So it's a question of the court then adjudicating on those rights.
Yes, You may switch off your mic. The second question is as follows. How would you distinguish between a question of law and a question of fact in determining the grounds for an intended appeal from the Labor Court, and what implications would this distinction have on the intended appeal's prospects of success?
Thank you, Chief Justice. A question of law refers to an inquiry as to the true position of the law, right? It is also a question whereby already the legal question was answered by legal authorities. And the duty of the court or judge is simple to identify that question of law. One can also go further and say a question of law involves the interpretation or application of the law. I can cite the case of Muzuwa versus United Bottlers, Supreme Court 25 of 94. It elaborated on what a question of law is. And then also, in the case of National Foods Private Limited versus Magaza, the court remarked that yes, a question of law usually is on the aspect of what the true position of the law is. But it also extends to situations whereby there is a serious misdirection of facts. And that serious misdirection of facts, then it's a serious misdirection in fact, and it's a misdirection in law, which means to say the wrong law was applied to those facts, and then it's tantamount to a question of law. Perhaps if with the indulgence of the Chief Justice, I may need the other part of that question.
What implications would this distinction have on the intended appeal's prospects of success?
Thank you, Chief Justice. Merely labeling a set of facts as a question of law is not enough. It must be clearly shown that indeed there is a question of law. And for an appeal, it's usual on a question of law, and therefore, if it fails to meet the requirements, it won't succeed. I can cite the case of Tendai Bonde versus National Foods, Supreme Court 2021. Appellant appealed to the Supreme Court, purportedly raising a question of law. But the Supreme Court held that no. Appellant was simply regurgitating the facts. There was nothing that shows that it pertained to a question of law, and that appeal failed on that ground. So, if the requirements are not met, there won't be a successful application.
The third and last question is as follows. Does the right of an employer to commence disciplinary proceedings against an employee prescribe? Justify your answer.
Thank you, Chief Justice. Like any other employment issue, if it came to the knowledge of the employer that there was need to institute disciplinary proceedings, and he doesn't do that, Labor Matters prescribed within 2 years. So I would say yes, as long as the position of the law is that Labor Matters prescribe within 2 years and the employer will be out of time. That means his intended action to convene a disciplinary hearing against the employee would have prescribed.
Thank you. I will now hand you over to the other commissioners for further questions, if they have. Yes, this.
Yes, thank you, Honorable CJ. Good afternoon, Mr. Ove.
Afternoon, Deputy Chief Justice.
I have one question for you. Having regard to the provisions of Section 176 of the Constitution, how do the powers of the Labour Court differ from those of the High Court?
Thank you, Deputy Chief Justice. Section 176 of the Constitution clearly states that the Constitutional Court, the Supreme Court, and the High Court have inherent powers. Therefore, the Labour Court, being a creature of statute, its powers differ from those of the High Court in that the High Court has got inherent powers which the Labour Court does not have.
If you could clarify a bit, does the same, what you just said, does it relate to the inherent power of the courts to regulate their own processes. And we are looking really at the High Court and the Labour Court.
Sorry. Yes. In other words, you seem to understand Section 176 in a very interesting way, which it doesn't say. You seem to understand it as saying it gives those courts inherent power. That's what I think it is. Does it do that? Otherwise, they would be beyond the law. Is that what that section says?
My understanding is that Section 176 of the Constitution simply outlines courts that have got inherent jurisdiction. And the High Court is mentioned as one of those courts. So, in my attempt to answer the question as to how the powers of the Labour Court differ from those of the High Court, my response is that they differ in the sense that the High Court has got inherent powers and the Labour Court doesn't have.
So can I go back to the question? You said, you are saying that you are referring to the provision providing for inherent powers. Are you able to specify what type of powers this Section 176 actually is talking about?
I think that calls for one to maybe explain what inherent powers mean.
We are concerned about what Section 176 says.
Maybe if I may,
so that
is
if
it
you are
176 of the Constitution?
Section 176 of the Constitution. If you cannot recollect the content of that section, then you are disabled or disadvantaged in terms of actually answering the question.
Understand the section does say you don't understand it, you have not applied your mind to it. Don't guess something that clearly is not true in terms of the laws. You can see we are already at you that you have an unusual view of Section 176, to tell you the truth, because if we took your position, those courts would be beyond the law. Because that's not what 176 says. You understand what, yeah.
I have no other question.
We take it that you have no answer to the DCJ's question. Yeah.
Thank you, Honorable Chief Justice. Good afternoon. Yes, I am also going to put one question based on your personal and professional profile. Yes, I notice from your profile that you have been a public prosecutor for the past 18 years. In fact, you are a career public prosecutor. Now, I just wanted to find out to what extent have you interacted with the Labour Court?
I have interacted with the Labour Court only to the extent of reading some judgments, especially those ones that would also have attracted public attention. I can give the example of the Zimbabwe petroleum judgment. I also became curious to go over it. And I can say that is the extent to which I have interacted with the Labour Court.
So, in other words, how long can you say you have been reading these judgments and taking interest in matters of the Labour Court? For how long have you been reading these judgments, or rather, for how long have you taken interest in following up on labor cases other than the time of the Zimbabwe petroleum case, which you have cited?
I cannot really say the period, but what I'm saying is that as and when judgments of interest arise as a lawyer, you become keen to say, let me look at this judgment. I cannot say maybe I've got a really time frame to say after what a period, but as and when a matter of interest arises.
Yes, I see, and we all agree that the Zua case was widely publicized, and in fact, all employers may have taken interest in that case. Would you have any other case other than the Zua case which you would like to share with the commissioners?
Yes, I also have the Nari versus Mugabe and others judgment.
What is it about? Or what is the import of that judgment?
Right, the import of that judgment was that it settled the controversy that has been in the courts as to whether given the fact that the High Court has jurisdiction over all civil and criminal matters in Zimbabwe, whether that jurisdiction also extended to dealing with labor disputes. And the Zua garage, that Nari versus judgment clearly articulated the position that as much as the High Court is given those powers by the Constitution, that judgment noted that the same Constitution also established specialist courts like the Labor Court, the Administrative Court, and actually remarked that if the High Court was to deal with all cases, including the labor cases, then why then create a specialist courts?
So did you find that to be in the public interest, and if so, for what reasons?
Not necessarily. I mean, I'm just answering the question to say what other judgment. I'm saying, in my view, this is one also of the judgment that I just stumbled upon and read, and realized that it raised very interesting issues.
Thank you. I have nothing further, Chief Justice.
Thank you, Chief Justice, and good afternoon, Mr. Obe. Right. My first question to you is this. What is the effect of an appeal to the Labour Court on the determination or decision being appealed against? Okay. What is the effect of an appeal to the Labour Court on the determination or decision being appealed against?
Thank you, Commissioner. An appeal to the Labour Court does not suspend the decision or order appealed against.
Is that your answer? Can I proceed to my second question? Yes, my second question to you is, what is the effect of an appeal to the Supreme Court on a Labour Court judgment or order?
The effect of an appeal to the Supreme Court of a Labour Court judgment is that it suspends the operation of that decision or order, and the authority that I have for that is Kingdom Bank Workers Committee versus Kingdom Financial Holdings.
Thank you, Mr. Howard. Thank you, Chief Justice.
Thank you, Chief Justice. Good afternoon, Mr. Owe.
Afternoon, Commissioner.
I have one question for you. And the question is, can a judgment of the Labour Court be executed or implemented pending an appeal to the Supreme Court? And if so, under what circumstances?
Thank you, Commissioner. As I've indicated that an appeal of a decision of the Labour Court to the Supreme Court suspends the operation of that order. It means that for it to be executed, one then has to apply for leave to execute that judgment pending appeal.
Thank you, Honorable Chief Justice.
Thank you. Good afternoon, Mr. Howe.
Afternoon.
Yes, what would you say are the best or good attributes of a Labour Court judge?
I would say a Labour Court judge like any other judge, must embrace the principles guiding the judiciary as enunciated in Section 165 of the Constitution, as well as the ethics enunciated in the Judicial Services Act, such as integrity. A labor court judge is someone who should have integrity. You should be beyond reproach, so to speak, in and outside the court. You must exhibit conduct that shows propriety, and must also uphold the Constitution, because in terms of the guiding principles in Section 165, it calls for individual and collective observation of the Constitution by judicial officials, as well as protecting human rights.
Thank you. I've got one more question for you. What factors does the Labour Court consider in the assessment of damages in cases of unlawful dismissal? What factors does the Labour Court consider in the assessment of damages in cases of unlawful dismissal?
Thank you, Commissioner. I think in the case of CFI Holdings, the court remarked that the issue of damages should be informed by evidence. A court should not just order damages arbitrarily without any supporting evidence to say how it has arrived at those damages. Besides the issue of quantification, but the whole essence is that there should be evidence. So, in my view, that is the most critical issue or factor that has to be considered. And then the court will be guided by factors such as when that person was dismissed, and maybe the date that the person found new employment or expected new employment. But basically, damages should not be arrived at in the absence of evidence.
Thank you, Honorable CJ.
Yes. Thank you very much, Chief Justice. Good afternoon, Mr. Hove. I just want to have a conversation with you around issues of a learning orientation as a key value of, for a judge. I hope we agree that a person in the position of a judge ought to consistently identify opportunities for personal and professional growth. All right? Correct? If you don't agree, then I will not proceed with the question. And also identifies opportunities to develop their skills and identify opportunities for training programs that might be offered by their employers, and so forth. Correct? If we agree that, in fact, that is important, I would want you to describe a situation in the past where you felt that you had specific technical gaps in your skills and competencies, and indicate clearly what it is that made you realize that you had these kind of gaps in your skills and competencies, and the nature of the action that you took, and what you would do differently if you were appointed as the judge of the Labour Court. I would want you to share an experience in the past. Share a situation in the past where you identified at a personal level that you had a gap, a shortcoming, a weakness in your set of skills and competencies, on the basis of which, of course, you were doing your work. What is it that actually made you realize that you had such a gap? What action did you take in order to close that gap? If, in fact, you realize that this is the case in the event that you are appointed as the judge of the Labour Court, would you do things differently? That's the set of questions I would want, just to get a sense of your understanding of a learning orientation. Is a key principle and value of a judge of a Labour Court.
Thank you, Commissioner. If I have understood you well, what I can say is that there is always need for one to advance their or broaden their knowledge.
Yeah, I won't let you go in that direction. That's now common cause, because that's why I asked. Remember how I prefaced my question? I said, you agree that this is important. Now I want you to focus on, give me an experience in your past professional life. That's where we should start.
In my professional field, I think I identified the need to advance my studies so that I can be able to understand issues related to my work. And in that vein, I did Master of Laws in Criminal Law because I realized that it was important in my area of prosecution. So I can say that was motivated by the fact that you will have the quest to acquire more knowledge in order to be more effective in your job.
Thank you very much. Let's go back to these technical issues. I suspect that there are instances where lawful limits can be imposed on the right of employees in Zimbabwe to form, join, and participate in the activities of trade unions and employers' organizations of their choice. Correct?
In terms of the Labor Act,
are there instances where lawful limits can be imposed on employees in this country to join, participate in activities of trade unions and employers' organization of their choice?
Actually, if that happens, it will be an unfair labor practice because in terms of the Labor Act, Part 2 outlines the fundamental rights of employees, which, amongst others, are to join a trade union, participate in a lawful collective job action. Therefore, insofar as the Labor Act is concerned, a contravention of those Part 2 rights is an unfair labor practice. I have not come across a section in the Labor Act that sanctions that. All I've come across is that any attempt to hinder or prevent an employee to join a trade union is an unfair labor practice.
Does the Constitution have any provisions relating to this matter?
Yes. Section 65 of the Constitution talks about labor rights. And it states that an employee has a right to safe, fair labor practices and standards, and also a right to be paid reasonable wages. And I think subsection 3 it is the one that also spells out that employees, it's their right to join trade unions, to engage in collective job action. It is a constitutional right.
Including members of the security services? Including members of the security services, that it is their right to form, join, and participate in the activities of trade unions and employers' organizations?
No, it specifically
Okay, no, that's fine.
excludes members of the security services.
Okay, so at some point we need then to square that circle, isn't it? Okay, thanks.
Chief Magistrate.
Thank you, Honorable Chief Justice. Good afternoon, Mr. Hove. I have one question, which is in two parts. What are the limitations regarding the Labour Court's authority to vary or rescind its own orders upon application by either party? The second part, does such an application stay the execution of the pre-existing court order? Okay. What are the limitations regarding the Labour Court's authority to rescind or vary its own orders upon application by either party? The second part, does such an application stay the execution of the pre-existing court order?
Thank you, Commissioner. In terms of Section 92, capital letter C, the Labour Court is empowered to rescind or vary its own decision. And it is one of the issues that point to the informality of the nature of proceedings in the Labour Court, to say it is allowed in certain circumstances, especially under Section 92C, to vary or rescind its own decision upon application by a party.
My question is, what are the limitations that the Labour Court has as it is varying it? What are the limitations? What are the do's? What are the don'ts outlined in the section that you're talking about?
That one, maybe, if it may pass, perhaps I go to the second one. If you may repeat that second one, Commissioner, that one on the limitation of...
Does such an application stay the execution of the pre-existing court order?
it is an application for stay of execution. Yes, it does.
Are you done?
Yeah.
Thank you, Honorable Chief Justice.
Thank you, Chief Justice. Good afternoon, Mr. Hove.
Afternoon, Commissioner.
You have the privilege of being a teacher as well as a lawyer. What is the meaning of the word interaction? What is the meaning of the word interaction?
I can say interaction generally refers to association.
Let me take that definition. By that definition, what association have you ever had with the Labor Court?
My association with the Labor Court is limited to perusing the judgments from that court.
That is just my problem. How do you interact or interact with something by reading a document? Doesn't interaction necessarily involve action between two entities? Have you ever had any interaction with the Labor Court? Reading judgments is not interaction. Have you ever had any interaction with the Labor Court?
Not to the extent whereby maybe having a matter in the Labor Court, no.
Have you ever had any interaction with the Labor Court? We're not talking about reading judgments.
I have not.
What makes you think you are qualified to go and preside over a court you have had absolutely nothing to do with in your 18 or so years as a lawyer?
Thank you, Commissioner. First and foremost, I am a lawyer, and labor law was one of the courses that I did in my studies. And I know the sources of law. I know how to apply the law, interpret the law, and therefore it's not like venturing into uncharted waters by positioning myself to occupy the office of Labor Court judge, because I have got all the skills, I've got all the attributes that are needed to occupy that office.
You have only ever done prosecution. Have you ever litigated or appeared in a civil court? Have you ever litigated or appeared in a civil court?
No.
You started a Master of Laws in Corporate Law in 2013. Is that correct?
Yes.
And in 2025, it is not yet complete. Why?
Thank you, Commissioner. What happened was that, as you can see from the papers, I passed all the courses of Master of Laws in Corporate Law. That includes Company Law 1, Company Law 2, drafting of commercial contracts. Now, when it came to the research aspect, which is the last component for you to be awarded a master's degree, the supervisor I had been allocated left employment, and that was communicated to me by the university. And it was clear that they were not sure as to when they will find a replacement, because my understanding is that each area of research that one chooses, there are usual supervisors for that field. And my area happened to be one where that supervisor was to take me through, but left employment. And then I had to weigh my option to say, okay, I cannot just wait. Let me register for another master's degree, the criminal law. So I'm hoping that I can then revert to the university to find out whether I can proceed to do the research component. What I'm aware of is obviously the curriculum change. There might be some courses that I might need to do, but basically I'm saying that is how I switched from corporate law to criminal law, because I had no supervisor at that time.
Are you aware of the mark you scored in the examination prior to this interview? Are you aware of the mark that you scored in the examination in the build up to this interview?
The mark for the first interview?
Yes.
Yes, I think it was communicated to me.
And with the mark that you got on your knowledge of substantive labor law, you still chose to proceed with the interviews? I'm saying, and with the mark that you scored on substantive labor law, you still chose to proceed with the interview?
Perhaps if you may clarify, is it the mark for the first JSC interview or the mark for the...
The mark for the first interview, for the examination, which was the first part of this process, you scored a very poor mark on your knowledge of labor law. And I'm asking, having scored such a poor mark on your knowledge of labor law and such a poor mark on your knowledge of procedural law, you still saw it fit to proceed and come to this interview, yes or no?
In my view, the first interview was a combination of both the ECMS and on labor issues, so I wouldn't really know whether it was the ECMS component or the substantive labor law issue that maybe contributed to that mark. But what I know is that I have the capability to excel in this field.
Thank you, Chief Justice. I have no further questions.
Chief Justice, thank you. I have no question.
Yes, thank you. We have come to the end of your interview. You are excused. Yes, you may sit down. Thank you. Yes, just confirm, we have Jaravani motion. Yes, thank you. As I indicated to you earlier on, I will be asking you 3 questions. And the first question is as follows. How does the compulsory arbitration mechanism in section 93, subsection 5, subparagraph A and C of the Labor Act correspond to the constitutional guarantee of the right to access the courts under section 69 of the Constitution, if it does? Can you help him to switch on the microphone?
Thank you. Yes. Section 93, subsection 5, paragraph A of the Labor Act provides for referral of labor matters to compulsory arbitration by a labor officer where the issue is not settled and where the employees are involved in disputes of interest and engaged in essential services. Then section 93, subsection 5, paragraph C provides for compulsory arbitration where the issue is not settled on conciliation and the parties have a dispute of right. How it relates to section 69 of the Constitution, which grants people a right of access to the courts in the determination of rights, is in the sense that labor law is a unique field of law which should be based first on an attempt to resolve disputes through alternative dispute resolutions mechanisms, which should start at shop floor level. So I would not say that this is a delay or an inhibition of parties from accessing the courts, because those alternative dispute resolution mechanisms are appropriate for labor disputes. So it's in tandem with section 69 of the Constitution. That is my answer to this one, Sir Chief Justice.
Yes, you may switch off your mic for now. The second question is as follows. How would you distinguish between a question of law and a question of fact in determining the grounds for an intended appeal from the Labor Court, and what implications would this distinction have on the intended appeal's prospects of success?
Section 92F of the Labour Act provides that appeals from the Labour Court to the Supreme Court shall be on questions of law only. And the first part of the question asks me to distinguish between a question of law and a question of fact in grounds of abuse from that level. The distinction was well articulated by the court in the case of Muzuva versus United Bottlers. A question of law can be understood in three distinct but related senses, namely that it is a question on which the law has authoritatively provided an answer to the exclusion of the exercise of discretion by the court on what is the truth in view of the evidence led. Then the second sense is simply a question on what the law is, meaning to say the court will be inquiring on what is the appropriate rule of law on the subject matter. Then the third sense in which a question of law may be understood is what is in the province of the judge as opposed to what is in the province of the jury. Of course, this may not be directly applicable to our system where we have no jury system, but it is relevant where a judge sits maybe with assessors. When we determine what can an assessor do and what can an assessor not do, it may also serve as a guideline to determine whether an issue is a question of law. Then question of fact, this one is simple. What evidence has been laid? What factual findings can be made from the evidence laid without maybe going to the legal aspects of assessing the probative value of the evidence. But the distinction may be blurred where we say that a gross misdirection on factual issues may then constitute a question of law. This is how it then links to the implication of the distinction on intended abuse prospects of success. So basically, the prospects of success of an appeal hinge on whether the appellant has managed to raise grounds of appeal which raise questions of law as opposed to questions of fact. That is my answer to this one, Sir Chief Justice.
The third and last question is as follows. Does the right of an employer to commence disciplinary proceedings against an employee prescribe? Justify your answer.
Section 94, subsection 1 of the Labour Act provides that no labour officer shall attempt to settle or resolve a dispute unless it has come to his attention or has been brought or has been referred to such labour officer within 2 years from the date when it first arose or when the aggrieved party first knew about the existence of the dispute. And I would say an employer also has rights which are protected by the Act, and an employer is also entitled to approach dispute resolution mechanisms provided for under Section 12 of the Act, that is Section 93 to Section 101 of the Act. So, an employer where it is or he is or she is an aggrieved party is subject to the laws governing prescription of disputes. That is how I understand it in view of the provisions of the Act, Sir Chief Justice. Thank you.
Yes, thank you. I'll now hand you over to the other commissioners for questions, if they have. Yes, CJ.
Yes, thank you, Honorable CJ. Good afternoon, Mr. Jarawani.
Good afternoon, DCJ.
I have one question for you. Having regard to the provisions of Section 176 of the Constitution, how do the powers of the Labour Court differ from those of the High Court?
Section 176 of the Constitution provides for the common law inherent jurisdiction of the Constitutional Court, the Supreme Court, and the High Court to regulate its own processes and develop the customary law and the common law. While the Labour Court is a creature of statute, of course, it is constituted in terms of the Constitution. Section 172 of the Constitution creates the Labour Court, subsection 1 of which provides for the composition of the Labour Court. Subsection 2 provides for the powers of the Labour Court, that it has jurisdiction in labour and employment matters, and an Act of Parliament may then confer jurisdiction on the Labour Court to exercise jurisdiction in labor and employment matters and the power to make rules. Then the difference between the powers of the Labour Court and those of the High Court is that the Labour Court is a specialist court with specialized jurisdiction. Section 89, subsection 1 of the Labour Act provides that, I will quote paragraph A of subsection 1, that the functions of the Labour Court shall, among others, include to hear and determine applications and appeals in terms of this Act or any other enactment. Then, if we are to go to the powers of the Labour Court, there has been confusion on whether a litigant can approach the Labour Court on issues within the concurrent jurisdiction of the Labour Court. I will refer you to the case of Nari versus Mugabe.
If I could just interrupt you, I thought you read the content of Section 176 of the Constitution quite well. You said that that section gives the higher courts, that is the Court, the Supreme Court, and the Higher Court, inherent jurisdiction to regulate their own processes, develop common law, and so forth. You correctly said that. So, does the same apply to the Labour Court? That's really all we are interested in.
Thank you, DCJ, for that. That does not apply to the High Court because it is a specialized court, which is to the Labour Court, which is a creature of statute, and it has no inherent common law jurisdiction.
Yes, thank you.
Thank you very much, DCJ.
Follow that. Just to clarify the DCJ's position and yourself, you are talking about creatures of statute. Is that what 176 is about?
No, 176 is about inherent common law jurisdiction. Then creature of statute, I'm talking about the Labour Court, Section 89 of the Labour Act as read with Section 172 of the Constitution.
But if you were saying the distinction of the High Court, the Supreme Court from the Labour Court, is that the Labour Court is a creature of statute. Is that a correct distinction based on 167 of the Constitution? Is that correct at law to say that? based on section 176 of the Constitution. Because if you say that, these other courts will be, they will not be legal courts. They would not be products of law. They are also creatures of statute. Supreme Court Act, for example, High Court Act, for example, creates those courts, talks about those courts. But like the DCJ has pointed out, the distinction is specific under 176.
Yes,
As to procedure, is specific as to what the other courts can do insofar as their powers is concerned, which the labor court cannot do because it is not tabulated in that section. You understand the difference?
Thank you for that, Chief Justice.
Sorry?
Thank you, Chief Justice, for that clarification.
You don't think me, you understand the distinction
Yes, Chief
in
Justice.
terms of the law.
Yes, Chief Justice.
So is your answer correct? Is your answer to the Deputy Chief Justice's question correct?
Yes, it was correct, but although it has some additions,
How was it correct?
it was correct in highlighting that the High Court and other superior courts have inherent common law jurisdiction, while the Labour Court does not have. Of course, I then extended it to say it's a creature of statute, which is where you corrected me. That is how I understood it, Chief Justice. Thank you.
Chief Justice, I have no questions.
Yes.
Thank you, Chief Justice. Good afternoon, Mr. Jaravan.
Good afternoon, Commissioner.
Yes, just one question from me. What is the effect of an appeal to the Labour Court on the determination or decision being appealed against?
An appeal to the Labour Court from other dispute resolution mechanisms which are inferior does not suspend the effect of the decision being appealed against, but the court may grant appropriate interim relief for execution or suspension of execution pending appeal. Section 92E of the Labour Act.
Thank you, Mr. Jaravan. Thank you, Chief Justice.
Thank you. Thank you. Yes.
Thank you, Chief Justice. I don't have any question for the candidates.
Yes, thank you, Honorable CJ. Yes, Mr. Jaravani, good afternoon.
Good afternoon, JP.
Yes, what factors does the Labour Court consider in the assessment of damages in cases of unlawful dismissal?
The basic principle is that an unlawfully dismissed employee should not sit around and do nothing while challenging the unlawful dismissal. Such employee is obliged to seek alternative employment. The court will consider the reasonable duration it would have taken for such employee
Oh, they're back.
Back. All right, you can
Thank you. For such employee to obtain alternative employment, then if the employee had sat around and done nothing, the potential amount which he or she would have earned during the period he was supposed to obtain other alternative reasonable employment will then be deducted from the damages which should have been due to such employee. So the assessment would be whether the employee took some efforts to seek alternative employment, and if so, in what period was he or she supposed to then obtain such employment. If no efforts were done, then the issue of penalization, which I adverted to, will then be applied against such employee. And in principle, damages should generally be proved by the party who seeks them. That is what I can say in response to this question, DCJ.
The question for you: what new insights and perspectives will you bring to the role of a labor court judge if you are appointed to that court?
I will concentrate on issues of other dispute resolution mechanisms, because the basic role of the labor court is to facilitate the attainment of the objectives of the Labor Act in Section 2A of the Act. So those objectives will be a guide in my roles. How best can equity be achieved in the present scenario? Are labor matters not more circuitous than ordinary matters? Dispute resolution mechanisms should be straight and quicker. For example, I will refer you maybe to the provisions of the new proviso to Section 101, subsection 5 of the Labor Act as amended up to 2023, where a person who is aggrieved by a decision in terms of a code of conduct is then obliged to revert back to the labor officer for conciliation. I will compare this with Section 92D of the Act, if it still exists, which says a person aggrieved by a decision in terms of an employment code should then appeal to the labor court. Surely, this amendment may be retrospective in that the principle of labor law is that once a dispute has been conciliated upon and it goes for adjudication, the reverse should not be the normal order. So we are saying where a dispute is presided over in terms of an employment code, that is clear adjudication. Why would a litigant then need then to revert back to conciliation procedure? That is a reversal. So we will be talking about the easier achievement of justice, expeditious, effective, and cheap and quick resolution of disputes. So we try to spruce out the system to have it more convenient, because most of the persons who may be affected are employees who may have weaker bargaining power than the employers. So the procedures should be more instant and quick. That is my response on what I suggest, on what some of the things I note in the system, DCJ. Sorry, Judge President.
Thank you, Honorable CJ.
Yes, thank you.
Thank you very much, Chief Justice. Good afternoon, Mr. Jarawani.
Good afternoon, Commissioner.
Very short one. Can lawful limits be imposed on the right of employees in Zimbabwe to form, join, and participate in the activities of trade unions and employers' organization of their choice?
I hope I got your question well. Can lawful limits be imposed on the rights of employees to form and join and participate in the activities of trade unions and employers' organizations of their choice? Thank you. There are limits to the enjoyment of those rights. Section 104 of the Labour Act has an intricate notice network. When a person wants to participate in activities like collective job action and even the registration of trade unions, provisions are there. An unregistered trade union has no similar privileges with a registered one. All those are limits. They may not make representations, maybe to employment councils. So there are existing limits which are there and they are prescribed by law, and employees cannot then act outside those limits. So the limits are imposed, they are there. That is my response to this part. Then, for employers' organizations, employees may not join employers' organizations, but they join employees' organizations like trade unions, basically. Unless maybe where there is a collective bargaining agreement, then which collaborates then the efforts of all the stakeholders involved in tripartism, like employment councils, then that is where they can join, with then dues being deducted for next dues, the employer and the employee contributing. So everything is provided for, the act is intact, it's adequate, unless some appropriate reforms may then be necessitated by circumstances, because labor law is dynamic. That is my response, Commissioner.
Does the Constitution also provide guidance with respect to the nature of the lawful impositions that may exist?
Yes, by the Constitution, I hope you are referring to the National Constitution.
I beg your pardon for completeness, yes, the Constitution of Zimbabwe, yes.
Thank you. Yes, Section 65 of the Constitution provides for labor rights. So it provides for the rights of employees to participate in employees' organizations, with the exceptions of members of the security services. And the law may restrict the right of employees in essential services to then participate in those activities.
Okay, thank you very much.
Thank you, Honorable Chief Justice. I have no questions. Thank you.
Thank you, Chief Justice. I have no questions.
Thank you, Chief Justice. Good afternoon, Mr. Jalawan.
Good afternoon, Commissioner.
Yes. In your response, when you were nominated, you mentioned that, you were asked to make a comment on your suitability to occupy the office of a judge. And your simple question was, or your simple response was that I have the required qualifications and experience. This was a suitability question, and my question is, what are the required qualifications that you're looking at, and what experience that separates you from the rest, that makes you suitable? I don't know your understanding of suitability. Does it only centers on issues to do on qualifications and experience, or it's more than that?
It's obviously more than that. A person has to be a fit and proper person in terms of integrity and experience, basically. So what I provided was what I could have at that moment.
So you do not have integrity?
I do have it.
I'm responding to your answer. You said what you provided is what you had at the moment.
Yes, in terms of qualifications and experience, those are the basic requirements. Then I saw it maybe too repetitive to then include everything. Going to the book, usually that is done where there are allegations, where you need to refute the allegations. Then that is where the duty then to be explicit and detailed then arises. I felt just there's a basic minimum, and indeed I have nothing special to say about that. That is why I then made an ordinary response to the question.
But you understand that this question required you to do more, to convince us as to your suitability to occupy the office of a judge.
Indeed.
Thank you, Chief Justice.
Yes, thank you. We have come to the end of your interview. You are excused.
Thank you, Chief Justice and Commissioners.
Yes, just confirm we have Machinga Uta Naison.
That's correct, CJ.
Yes, fine, thank you. You recall that in the morning I indicated I will be asking you 3 questions. The first question is as follows. How does the compulsory arbitration mechanism in section 93, subsection 5, subparagraph A and C of the Labour Act correspond to the constitutional guarantee of the right to access the courts under section 69 of the Constitution, if it does?
Thank you, CJ. The right to the compulsory arbitration method provided for in terms of the Labour Act allows an aggrieved party to challenge the outcome of the proceedings by appealing to the Labour Court. So it confirms the right of the litigant to a fair hearing.
The second question is as follows. How would you distinguish between a question of law and a question of fact in determining the grounds for an intended appeal from the Labour Court, and what implications would this distinction have on the intended appeal's prospects of success?
When you appeal from the decision of the Labour Court on a point of law, you are challenging the court's findings on the law. That is different from when you are alleging that the court did not come to the correct conclusion on the facts. So the distinction, I would say, would make you able to decide whether or not you need to appeal from the decision of the Labour Court, because appealing from the Labour Court to the Supreme Court must only be on the basis of law.
You are done. You are done on this. All right. Yes, the third and last question is as follows. Does the right of an employer to commence disciplinary proceedings against an employee prescribe? Justify your answer.
Yes, Judge, it prescribes in terms of Section 94 of the Labour Act. The employer must bring its proceedings against the employee within 2 years from the date when the misconduct was allegedly done. So in terms of Section 94, the right to bring those misconduct proceedings against the employee will prescribe if that time frame is not met.
Yes, thank you. I'll now hand you over to the other commissioners for further questions, if they have. Yes, CJ.
Yes, thank you, Honorable CJ. Good afternoon, Mr. Machingauta.
Good afternoon, DCJ.
Yes, I have one question for you. Having regard to the provisions of Section 176 of the Constitution, how do the powers of the Labour Court differ from those of the High Court?
In the first instance, DCJ, the Labour Court is a specialized court, specifically set up to deal with labor and employment matters. So that is the difference between the High Court and the Labour Court. While the High Court is original jurisdiction in terms of Section 171.
If I could just interrupt, we are concerned about 176, Section 176. That's the one we are concerned with. And if you want me to repeat, having regard to the provisions of Section 176, how do the powers of the Labour Court differ from those of the High Court in relation to what Section 176 provides?
I hope I have a clear recollection of what Section 176 provides for. I would think, DCJ, that that section deals with I will let the question pass.
Yes, thank you.
Yes, thank you.
You, Honorable Chief Justice, and good evening, Mr. Machingauta. Now, I just want to find out, do you consider the IECMS as an important component in the dispensation of justice?
Yes, I do.
And if so, what have you done to improve yourself on that aspect? I say so, Mr. Machingauta, because you scored no marks at all on the preliminary interview for on the aspect of IECMS. So what are you doing to bring yourself up to date with modern ways of doing work?
Thank you very much for the question. Like I said, I do consider the IECMS as an integral part of today's lawyering. It is correct that I didn't score any marks in the written exam, but that was not because I do not know anything about the system. If you look at the results of last year's written exam, where I was a candidate for the judges of the High Court, I actually was able to access the question paper. What I was not able to do was to upload. This time around, I had actually mastered the art of accessing and uploading, but I realized that, in fact, being able to access and upload as a lawyer is not the same as being able to access and upload as a judge. So that's the component that I must familiarize myself with. But otherwise, I can say safely that from the perspective of a lawyer, I am able to access and upload. In fact, I had done a series of uploading and accessing before the written exam.
However, for that particular preliminary examination, you found it extremely challenging because you scored no marks.
I indeed, and I'm sure I have explained how that came about. I concede that.
And do you also realize that if you are proficient, you should not be selective to say, when I'm appearing as a lawyer, I'm good. When I'm appearing in this different capacity, I'm challenged. But in other words, let me just encourage you to embrace technology as a way of doing modern work. I have no other questions, Chief Justice.
Yes, thank you, Chief Justice, and good evening, Mr. Shingaut. Now, I have 2 questions for you. The first one is, what is the effect of an appeal to the Labour Court on the determination or decision being appealed against?
There is no effect, Commissioner. The judgment being appealed against remains in force until it is overturned.
Yes. Thank you. And the second question is, what would be the effect of an appeal to the Supreme Court on a Labour Court judgment or order?
I will kindly ask you to repeat the question again.
Okay, fine. Here it goes. What is the effect of an appeal to the Supreme Court on a Labour Court judgment or order?
Again, I would think that there is no effect because the order being appealed against remains in force until it is overturned.
Thank you, thank you, thank you, Chief Justice.
Thank you, Honorable Chief Justice. And good evening, Mr. Machingauta.
Good evening, Commissioner.
In your answer to the first question asked by the Honorable Chief Justice, you sounded like you are of the view that the fact that an aggrieved party can appeal to the Labour Court after compulsory arbitration is what you understand about access to the courts. Was I correct in construing your answer to that effect?
Well, Commissioner, I've answered a series of questions after that. I wouldn't have a clear recollection of what I said in answer to the Chief Justice's first question.
The question was about compulsory arbitration and how it corresponds to the constitutional guarantee to the right to access to the courts. And you spoke about an aggrieved party appealing to the Labour Court. So the question is, did I get you correctly in that regard?
You probably did, Commissioner.
And what is your understanding of access to the courts in the context of this question?
My understanding of access to the courts would be the avenue being afforded to a litigant to be able to take his case to court if he should think that he is aggrieved by a decision made at the workplace.
And that would exclude compulsory arbitration?
No, it wouldn't.
Okay, thank you, Chief Justice.
Thank you, Honorable CJ. Good evening, Mr. Machingauta.
Good evening, JP.
I have one question for you. What factors does the Labour Court consider in the assessment of damages in cases of unlawful dismissal?
Thank you, JP. There are a number of factors that the Labour Court will take into account in considering damages for unlawful dismissal. I will not state them in any particular order, but the court will take into account whether or not the litigant took any steps to mitigate his loss from the time that he was dismissed up to the time that the judgment is given by the court, or to the time when he appears before the court. The court will also take into account the fact of whether or not the employee or his employee's profession is one in which it is readily possible, I would say, to get a new job. If it is in a profession where jobs are available, the court would certainly take that into account. The court will also if you may bear with me. The court will also take into account the general economic environment in the country in assessing the level of damages that the court may award to the employee.
How does the court come up with the actual figure that is due to the employee?
In terms of the actual figure, it is not an easy decision, but the court will take into account how long the employee would have taken to get a new job, or what measures the employee has taken to mitigate his loss. It will, of course, take into account what the employee was earning and try to multiply that by the number of years or months it would have taken for him to get an alternative source of income. No, JP.
Thank you.
Thank you very much, Chief Justice. Good evening, Mr. Machinga Uta.
Good evening, Commissioner.
Yes. Can limits be lawfully imposed on the right of employees in Zimbabwe to form, join, and participate in the activities of trade unions and employee organizations of their own choice?
The question is a bit long, Commissioner. May I
Yes.
ask you to repeat?
Can lawful limits be imposed on the right of employees in Zimbabwe to be members of trade unions and participate in trade union activity? Trade unions of their own choice. Can you impose limits? What does the law say in that area?
Thank you, Commissioner. If you are an employer whose conditions of employment are governed by the Labour Act, your right to join a trade union and to participate in the activities of the trade union cannot be limited in the lawful. Employees, yes. I'm saying if you are an employee whose conditions of service are governed under the Labour Act, the Constitution protects your right to belong to a trade union of your choice, and also to take part in the lawful activities of that trade union.
Yes, that is as a general provision of law is correct. My question is, can limits be imposed on that right?
From the answer, Commissioner, no.
Okay, thanks. Thank you.
Thank you, Honorable Chief Justice. Good evening, Mr. Machingauta.
Good evening, Commissioner.
I have one question, which is in two parts. What are the limitations regarding the Labour Court's authority to rescind or vary its orders upon application by either party? The second part, does such an application stay the execution of the existing court order?
Thank you, Commissioner, for the question. I would have asked for the question to pass, but I will give it my best shot. The limitations would relate to where a litigant was in willful default, or where a litigant is not shown that he had lawful reason not to comply with the provisions of the Labour Act, of the rules of the Labour Court, I mean. So in that instance, the Labour Court would be limited in its ability to vary or rescind its own decisions.
Is that the only ground?
It is the one that readily comes to my mind, Commissioner.
Okay, and the second part of the question?
May I request that you read to me again the second part of the question?
Does such an application then stay the execution of the pre-existing court order?
The application to vary or rescind a decision of the Labour Court would not have the effect of staying the execution of the order, unless there is a specific application before the court, which the court would have granted to stay execution pending the finalization of the application to rescind or vary the Labour Court's decision.
Thank you, Honorable Chief Justice.
Thank you, Chief Justice. Mr. Machingauta, you have not been in legal practice in a very long time. Labor law, is that something that you think you can walk into at this stage?
Yes, Commissioner, it is correct that I have been away from the practice of law in the strict sense of the word, but I've always remained a lawyer, and in the last 3 to 4 years I have been teaching law at the University of Zimbabwe. I would therefore think that it is very possible for me to be a judge of the Labour Court and be able to function in that capacity without any problem.
When you were in Pindura, did you do much labor? Did you have much labor litigation?
When I was with Pindura municipality, my interaction with the Labour Court and the labor law was in respect of employment issues that would have arisen at the workplace, where we would appear before a labor officer for conciliation in my capacity as the legal advisor to the municipality. But I would also get the opportunity to interact with external lawyers who would be handling labor matters on behalf of the municipality. So that's as far as my interaction with the labor law and the labor court were concerned.
What I wanted to know specifically is, did the municipality have much litigation in the labor court?
At first, we had a lot of litigation, but with better management, the number of labor cases decreased quite significantly. So there were not a lot of labor cases at the time that for the remaining part of my position at my stint at Bindra municipality.
Thank you, Chief Justice. I have no further questions.
Thank you, Chief Justice. Mr. Machingawata, good evening.
Good evening, Commissioner.
Thank you. Confirm for me that your current employer is the University of Zimbabwe?
That is correct, Commissioner.
Thank you. I'm looking at your CV, yeah? Under professional references, you have 5 referees, and I do not see the University of Zimbabwe listed as any of your referees, but you have been there since 2021. Is there a reason why?
There's absolutely no reason, Commissioner. It is because at the University of Zimbabwe, I don't know if there is anyone who can say he knows anything about me, except perhaps for Dr. Mtangi, who is the chairperson of the postgraduate legal studies program. For everyone else, we don't meet. They don't even know that I'm at the University of Zimbabwe. So to answer your question directly, there is no specific reason why I have not put anyone's name from the university. It is precisely because I don't think that anyone will be asked to say anything about me and be able to say anything about me.
But the university is your current employer. So if you would want to know your current status as an employee, you would want information, where do we get that from? Because all these listed referees, I think they are from past employment, and I'm not too sure about this number 2 that you're calling Training Resources Group. Are they based in the United States? I don't know. Just seeing the phone number there.
Commissioner, the way I look at referees is that there must be people who can attest to my ability to discharge the functions bestowed upon me. If you look at some of those people, there are people that I mentioned on my CV. There are people that I have worked with. There are people who would be able to say, we worked with this patient during this period, and during his time with us, we would say that he is the kind of person who you could work with or who could not work with. I cannot say that about the University of Zimbabwe at the moment. Like I said, there's only one person, in my view, that could be in that position. But even then, I would have needed to consult with him to see if he was prepared to be my referee. But their exclusion from that list is not because they would possibly have anything against me. No. They can't. I've not done anything that would make them want to say anything adverse about how I discharge my responsibilities.
How long have you been with the university?
Since October 2021, I think.
My last question, Mr. Machingawata.
Yes.
Under publications, still on your CV, you have about 6 papers that are upcoming that you have listed. For 2025, 2026. None of them are in labor law. You seem to have an interest in public procurement, and also that's what you're teaching. So where do you really fit in this labor law discourse?
Commissioner, it is correct that my upcoming papers are in the area of public procurement law and local government law. It is correct, your observation is correct that there is no upcoming paper or an old paper that has been published on labor law. The reason is very simple for me. If you look at the jurisprudence on public procurement law in Zimbabwe, you will see that there is virtually nothing written on public procurement law. So I have taken it upon myself, and because this is a subject that I teach, I've taken it upon myself to try and make a contribution in the development of the jurisprudence in public procurement law. Public procurement law, as we know it today.
Mr. Shangawata, thank you very much. I've been answered. My question really is in the labor law dispute. Procurement, that's fine, but I think I've been answered. Thank you.
Thank you, Commissioner.
Thank you. We have come to the end of your interview. You are excused.
Thank you, CJ. I will be excused.
Thank you. bringing in candidates, please, can you speed up? Yes, sorry, you may sit down. Yes, we have Makwande Bianca. That is correct.
Correct, Honorable Chief Justice.
Yes. As I said in the morning, I'll be asking you 3 questions. And the first question is as follows. How does the compulsory arbitration mechanism in Section 93, subsection 5, subparagraph A and C of the Labour Act correspond to the constitutional guarantee of the right to access the courts under Section 69 of the Constitution, if it does?
Thank you for the question, Chief Justice. Section 69 of the Constitution provides for a fair hearing. And Section 69, subsection 3, speaks to the right to access to justice through the courts or any forum or tribunal established by the law. So Section 93, 5A and C speaks to a situation whereby they would be issued by a labor officer a certificate of no settlement. And when that is issued, if the dispute is a dispute of interest and the parties involved are of an essential service, then in terms of Section 93, subsection 5A, the parties must go for compulsory arbitration. And in terms of Section 93, subsection 5C, the parties may go for compulsory arbitration. So I believe that the right that is guaranteed in Section 69 corresponds with the provision of Section 93, subsection 5A and C, in that parties are afforded a chance to appear before a tribunal that is established in terms of the law. So the processes would then be governed by Section 98, subsection 10 of the Labour Act. Thank you.
The second question is as follows. How would you distinguish between a question of law and a question of fact in determining the grounds for an intended appeal from the Labour Court, and what implications would this distinction have on the intended appeal's prospects of success?
Thank you, Honorable Chief Justice. The appeals from the Labour Court are governed by Section 92, subsection 92F of the Labour Act. And the provision provides that one can only appeal to the Supreme Court on a question of law. A party who wishes to approach the Supreme Court must make an application before the Labour Court, and where the application is denied, the party has the right to make an application directly to the Supreme Court. So it is only a question of law that can be appealed against in the Supreme Court, and the courts have defined what a question of law is as opposed to a question of fact. The case that comes to my mind is Mutsuta versus Kaga, and also Muzuva versus United Bottlers, where the court held that a question of law is a question of which the law has authoritatively spoken of, with the exception of the truthfulness of the facts. It is also a question of what the law is. It is also the question which a judge alone, and not assessors or the jury, can decide upon. And then it also has been stated that where the misdirection by the Labour Court on issues of facts are so gross, then the facts can amount to a question of law. Thank you.
The third and last question is as follows. Does the right of an employer to commence disciplinary proceedings against an employee prescribe? Justify your answer.
Thank you, Honorable Chief Justice. I am of the view that the right of an employer to commence disciplinary action against an employee prescribes. I believe that from my reading, this can be provided for by the Code of Employment. And also Section 94 of the Labour Act provides for prescription for 2 years where a matter is not brought before a labour officer.
Thank you. I'll now hand you over to the other commissioners for questions, if they have. Yes, CJ.
Thank you, CJ. Good evening, Ms. Makwande.
Good evening, Honorable Deputy Chief Justice.
Yes, I have one question for you, and it goes as follows. Having regard to the provisions of Section 176 of the Constitution, how do the powers of the Labour Court differ from those of the High Court?
Thank you, Honorable Deputy Chief Justice. Section 176 provides for inherent jurisdiction for the Constitutional Court, the Supreme Court, and the High Court. In terms of that section, they have the power to manage their own processes and also to develop customary law and common law in line with the Constitution and the interest of justice. So the High Court, in that regard, has unfettered jurisdiction, inherent jurisdiction. I think it can be said that it can do anything that the law does not forbid. The High Court can deal with with a constitutional issue, save for those that are within the ambit of the Constitutional Court. The High Court can hear any criminal and civil matter across
Sorry, if I
Zimbabwe.
could just interrupt, could you restrict yourself to the provisions of Section 176? Yes, you have to understand, of course, what the import is of that section. Then you can relate your answers to that.
Do you understand that section? Section 176 of the Constitution. Do you understand it?
I believe I do, Honorable Chief Justice. What I wanted to bring out was the fact that the High Court is given inherent jurisdiction to manage its processes, to regulate its processes, and to develop customary law and common law, whereas the Labour Court does not have that jurisdiction. The Labour Court's powers are only provided for in terms of Section 8 and 9 of the Labour Court Act. I was also going to bring...
I think that answers the question fully. Thank you, Ms. Makwande.
Thank you, DCJ. Thank you.
Thank you, Chief Justice, and good evening, Ms. Makwande. Yes, I've got one brief question. In fact, my observation and conclusion from your profile and also from what you feel in your questionnaire shows that your interaction with the Labour Court is basically a result of during the course of your work as a senior judicial officer. Am I right?
Correct.
And not necessarily that you have appeared in the Labour Court. Is that so?
I would agree on that, that I have not physically appeared, but however, we have matters which we deal with in our department, labor law matters, where we instruct legal practitioners, and during that process, we are expected to read around the law on labor.
So, in light of that, can you therefore say you have been very current with the developments in the labor law and the respective jurisprudence? Can you say you are current?
Honorable Attorney General, I believe that to a larger extent I should be current to the developments in the labor law in view of the statement that I've already made to say that we deal with matters that go to the Labour Court where we have appeals by employees or JSC employees who would have faced disciplinary proceedings.
Honorable Chief Justice.
Thank you, Honorable Chief Justice. I have no questions for Ms. Makwanda.
Thank you, Chief Justice, and good evening, Ms. Makwande.
Good evening, Commissioner.
One question in two parts. Can a judgment of the Labour Court be executed or implemented pending an appeal to the Supreme Court? And if so, under what circumstances?
Commissioner, I believe that yes, a judgment of the Labour Court can be executed pending appeal, and that only occurs when such an application for execution pending appeal is made to the Supreme Court.
And what would be the basis of such an application, in short?
The basis for the application would be that the appeal that would have been filed is frivolous and vexatious.
Thank you, Honorable Chief Justice.
Check on this, because there seems to be a total misunderstanding of this area of the law. Are you saying that the making of an application to a Supreme Court grants a right to also to enforce a court order?
Honorable Chief Justice, an appeal that is made from the Labour Court to the Supreme Court suspends the sentence, or the decision, sorry, the decision.
You have now turned around the answer you gave to the question by Commissioner Okwe. Did you hear what, you understood what my question was about? You had said where there's been an application on what you call the grounds of frivolity and vexatiousness, the order will be suspended. I mean, the order will be enforceable, isn't it? The judgment can be enforced. Is that the correct position of the law? Is that what you understand the law to say?
My understanding, Honorable Chief Justice of the law, is that where an appeal is noted in the Supreme Court, the decision of the Labour Court is suspended, and where one intends to execute, they then must make an application to the Supreme Court to execute.
That's what my question is. Is that what the law is? Is that how a judgment of a Labour Court or any court is executable? Is that how you understand the law? To say that a making of an application grants a right to the execution of a judgment of a court, a lower court?
I may not be getting the question correctly, Honorable Chief Justice. What maybe I'm trying to say is that once an appeal is made to the Supreme Court, the
get worried. Don't get worried. There's no catch in it. I just want to know your understanding of the law. Because you are in an interview, we don't want you to remain hanging there and thinking you've given the correct answer, especially where the law is concerned. So your understanding of the law is that making an application to the Supreme Court grants a right to execute a judgment.
I stand corrected, Honorable Chief Justice. My view had been that if you make an application to execute and if it is granted, then one can then...
Yes, it is granted, it's given by a court. There must be a court order, not the application. The application is not, does not grant a right. It's a court. When then the court makes an order on that application, that's when execution on a court order, not an application. Otherwise, you have lawyers making law. They don't. They just make applications. Isn't it?
Yes, Honorable
That's what
Chief
we want
Justice.
to hear from you.
Yes, Honorable Chief Justice.
All right.
Thank you.
Thank you, Honorable CJ. Good evening, Ms. Makwande.
Good evening, Judge President.
I have two questions for you. The first one, if you are appointed to the Labour Court bench, what new insights and perspectives will you bring to the role of a Labour Court judge?
Thank you for the question, Judge President. I believe that if I'm appointed to the Labour Court bench, I will enhance what is already there. I will ensure that there is more efficiency and effectiveness in the hearing and determination of the cases that are there. So I will bring in my skills as an individual and also my experience and ensure that I, as I have said, enhance the operations.
The Labour Court, that which you are suggesting, is already happening. I'm talking of new insights and perspectives.
Honorable Judge President, I cannot off the cuff think of anything new that I'll bring, but what I can say is I will add on to what is already there, bringing in myself the qualities that I have as an individual to ensure that the operations are effective.
Very well. Next question. What factors does the Labour Court consider in the assessment of damages in cases of unlawful dismissal?
In the assessment of damages in cases of unlawful dismissal, the court will try to ensure to bring back the status quo ante for the employee, the dismissed employee. The employee would be entitled to the salaries that he was expected to be given had the unlawful dismissal not happened. The employee will also be entitled to benefits that would have accrued had the unlawful dismissal not occurred. It was also held in cases that in assessing damages, the court should consider that the employee during the time of the dismissal should have mitigated his or her loss in the sense that they should have looked for employment from the time that they are dismissed. So in the event that the employee could reasonably have been expected to have found employment, or in circumstances where the employee would have found other employment, then the damages would then be calculated from the date of the dismissal to the time when the employee would have found employment or could have reasonably been expected to have found employment.
Is that all?
Some of the factors that maybe the court will take into account are the skills and also the age of the complainant, the employee, amongst other issues.
Thank you so much for your answer. Thank you, Honorable CJ.
Thank you. Good evening, Ms. Makwande.
Good evening.
I just wanted you to indicate the limits that can be lawfully imposed on the right of employees in Zimbabwe to participate in activities of trade unions and employee organizations of their choice.
Honorable Chairperson, the rights for employees to participate in activities of trade unions and organizations of choice are provided by the Constitution. Section 58 speaks to the right of association. Section 65 speaks to the right to join and participate in trade unions and organizations. They only...
You said section what? You mentioned two sections. Did you say section 58?
I mentioned...
I just want... Which section did you mention? Did you say 58?
I say, yes, I say...
You say it 58?
Yes.
All right.
So the only limit would be for security services and also where the activities are unlawful.
Public institutions that would generally experience interventions that limit their the participation of their members in activities of trade unions and other organizations beyond the security services, are they not?
I am not sure of that. I would believe maybe essential services.
Okay. Yeah, there would be essential services. Health is a case in point. In fact, that is particularly captured even in the statutory instrument that relates to the Health Services Act. Thank you very much.
Thank you, Commissioner.
To clarify that, you are still saying 58 is relevant to the question. You think it's relevant to the question by Dr. Ungwe on the right of employees to form, join, and participate in trade unions. You say Section 58 of the Constitution is relevant.
My view is that to the extent that it allows for the right to association, but the section...
No, I'm just asking you, you think that it is a relevant question is over?
No, Chief Justice.
Oh, why did you mention it?
My view, Chief Justice, at that time was that it was connected to the right of the employer insofar as association is concerned. But on hindsight, I'm of the view that the section that speaks directly to it is Section 65.
Section 65?
Yes.
Sorry, Section what?
65.
65?
Yes.
So what has 58 to do with 65? There are two sections equal in provision and strength to each other because they are fundamental laws in a constitution. So how do one relate to that? You can't mention both in an answer to a question like that, can you? Unless you don't understand what you are talking about. Why mention for 58 if it's 56? It's 65.
I retract that, Chief Justice.
Okay. Anyway, fine.
Thank you, Honorable Chief Justice. Good evening, Ms. Makwande. I have one question which is in two parts. What are the limitations regarding the Labour Court's authority to rescind or vary its own orders upon application by either party? The second part of the question is, does such an application stay the execution of the pre-existing court order?
The Labour Court can only vary or rescind its judgment where there is misrepresentation or fraud, or where there was a default judgment or a mistake that is common to the parties. It cannot vary where a review or an appeal has been filed. My view is that such an application does not stay the proceedings.
Thank you, Honorable Chief Justice.
Thank you, Chief Justice. Mrs. Makwande, during the performance appraisal for 2024, your appraiser mentioned that you need to put more effort into the production of law reports. Do you appreciate that a judge has to produce judgments tediously? And if so, how are you going to get over this hurdle of delaying in delivery?
Thank you for the question, Commissioner. Indeed, that is the comment that I got during my performance appraisal. And I made an undertaking to my supervisor that as a department would put in interventions to ensure that we speed up the production of the law reports. In the event that I am appointed to be a judge of the Labour Court, I will ensure that I timeously deliver judgments, because I'm alive to the fact that the position that I'll be holding is one of public trust, and what is expected of me by the Constitution and the people of Zimbabwe is that I should give judgments speedily. It therefore means that I will put all the effort to ensure that after hearing a matter, I have to sit down and pen a judgment in time.
Are you suggesting that your current office is not one of public trust?
Sorry, I beg your pardon?
You said you would make the effort because you are aware that you, as a judge, you would be holding a position of public trust. I'm asking if your current position is not one of public trust.
Definitely it is. It is.
I have no further questions, Chief Justice.
Thank you, Chief Justice. Good evening, Ms. Makwande.
Good evening, Commissioner.
Thank you. I'll follow up on the question of law reports. You talked about interventions that the office has put in place. Have these interventions been put in place? Is it still a blueprint? If they have been, what interventions have you put in place to ensure that we have experienced production of law reports, having noted that there is a problem around that area?
Thank you, Commissioner. One of the main challenges that we were facing insofar as the production of law reports is concerned is the delay by some editors in bringing work, and also bringing back judgments, and also the manner in which we were handling the production of the law reports. So the intervention that has been put in place is that there has been a standalone section that has been put in place to solely deal with the issues relating to the production of law reports.
Thank you, Chief Justice.
Yes, thank you. We have come to the end of your interview. You are excused.
Thank you.
Yes, just confirm we have Manuere Taurai.
I confirm,
Yes, thank
Chief
you.
Justice.
As I said this morning, I will ask you 3 questions. The first question is as follows. How does the compulsory arbitration mechanism in section 93, subsection 5, subparagraph A and C of the Labour Act correspond to the constitutional guarantee of the right to access the courts under section 69 of the Constitution, if it does?
Section 93(5)(a) of the Labour Act provides that if the labour officer has failed to resolve the dispute through conciliation, he issue a certificate of no settlement and consult his senior, and then if the dispute is a dispute of interest and the parties are engaged in essential service, he shall refer the dispute to compulsory arbitration. So, this section endowes the parties with the right to justice because their dispute is going to be adjudicated by the arbitrator in trying to resolve that dispute. The same applies to section 93(5)(a), relate to a dispute of right. The labor officer may refer that dispute to compulsory arbitration for it to be adjudicated there. The arbitrator can resolve that dispute through conciliation and adjudication, thus affording the parties thereto the right to seek recourse, and therefore they have a right to justice. That's my answer, Chief Justice.
The second question, you may switch off the mic. The second question is as follows. How would you distinguish between a question of law and a question of fact in determining the grounds of an intended appeal from the Labor Court, and what implications would this distinction have on the intended appeal's prospects of success?
The distinction between a question of law and a question of fact is fundamental, because an aggrieved party can only appeal against the decision of the Labor Court on a question of law, not on a question of fact. And when we relate to question of law, it means the judge would have misinterpreted the law or would have misapplied the law. However, a gross misdirection of fact constitutes a question of law. So, if a litigant is able to distinguish the two, he will be able to then file an appeal on a question of law, arguing that the Labor Court misinterpreted the law, or misapplied the law, or there was a gross misdirection on the application of the law, which is outrageous in its defiance of logic. Thank you, Chief Justice. That's my answer.
Yes. The third and last question is as follows. Does the right of an employer to commence disciplinary proceedings against an employee prescribe? Justify your answer.
My answer, Chief Justice, is that it prescribes, because disputes must be resolved within 2 years from the time of occurrence. So if the employer does not institute disciplinary proceedings within that 2 years and does that after 2 years, then it prescribes, unless if that dispute that misconduct is continuously recurring. That's
Thank you. I'll now hand you over to the other commissioners for further questions if they have. Yes, President.
Thank you, CJ. Good evening, Mr. Manuere. I have one question for you. Having regard to the provisions of Section 176 of the Constitution, how do the powers of the Labour Court differ from those of the High Court?
sorry, Deputy Chief Justice. Kindly repeat the question for me.
Very
Thank you.
well. Having regard to the provisions of Section 176 of the Constitution, how do the powers of the Labour Court differ from those of the High Court?
That particular section, if I'm not mistaken, endows the High Court and the Supreme Court with inherent jurisdiction to regulate their own proceedings. And if I'm not mistaken, and also to develop common law in terms of the Constitution and the interest of justice. In that regard, the difference is that the Labour Court is a creature of statute, and it does not have inherent jurisdiction in that regard. I think that's the major difference in that area. Thank you, Deputy Chief.
Thank you. Thank you.
Thank you, President. Yes.
Thank you, Chief Justice. Good evening, Mr. Manuere. Yes, Mr. Manuere, I will touch on your personal profile, including your work ethic. To start with, Mr. Manuere, during the course of the preliminary examination, you exhibited very limited knowledge of labor law. And as a presiding magistrate aspiring to be a judge of the Labor Court, how are you addressing this?
A good judicial officer is one who is able to find the applicable law through research and then apply that law to the facts. As a judicial officer of 21 years experience, I think I am able to discharge my duties, research the law, find the law, apply it to the facts. I will not have any difficulties in doing that because I've been doing that. If I find difficulties, I will research, find the law, evaluate the evidence, then apply those facts, the law to the facts, and come up with a reasoned judgment.
Thank you for that plan of action. Unfortunately, you scored very lowly, 5 out of 30. That was very low. Anyway, again, there's a worrying evaluation report pertaining to yourself, Mr. Manuel, whereby you have not been expeditiously disposing of cases in your court. Are you not going to export that work ethic to the labor court in the event that you are appointed judge?
I must admit that there are 1 or 2 cases that I took long to finalize. But, sorry, in most of my cases that I preside over, I make sure that I dispense justice expeditiously and deliver my judgment in time. Save for few cases that has taken long to finalize. I know of one case that has exceeded, gone up to 12 months, but it is not because of my own making. There are contributing factors that are making me not to finalize that particular case. If I'm appointed, I assure you that I'm going to deliver justice expeditiously because I'm conscious that justice denied is justice delayed.
So what number of cases on average do you consider a diligent person in your circumstances to complete within, say, a month? How many cases?
Between 10 and 15.
Between 10 and 15?
Yes.
But you've been doing less than 5 cases. You've been doing less than 5 cases.
I admit, but if you look previously when I was in the regional court dealing with rep matters, I was completing between 8, 10, and so cases. That number reduced when I was then transferred. Transferred from the regional court into the anti-corruption court.
Yeah, but the conduct seems to persist because the statistics of less than 5 cases per month was for 2024, and currently you have got an average of 3 trials per month. You are even deteriorating in your performance. So how do you then become a judge of the labor court if you are so slow? You don't, give importance to expeditiously finalizing cases.
Yes. I will assure you that I'm going to dispense justice expeditiously. If I'm appointed.
You are going to change. Is that an undertaking that you are going to change from your current bad habits?
I am definitely going to change. I'm going to change because starting from next month, you will see that I'm going to complete more cases.
Thank you, Chief Justice.
Why have you been doing that? change or no change in the future, why have you adopted a bad habit of not completing cases, of delays, warnings, complaints, and you don't seem to have changed. You are promising only to change after this interview. Why have you been doing that?
Chief Justice, there are a number of contributing factors that is attributed to that, especially in the anti-corruption court. You deal with a number of cases in which they are legally represented. I can tell you one that I know for certain. The legal practitioner for the second accused person was not feeling well, resulting in a number of postponements.
Of certain cases, even where the so-called accused persons have been crying for you to complete. We have them, and you just didn't do anything. You remember the Mahere case? She was there pursuing you to complete her case. You didn't do it for, I think, 8 months. Just an interlocutory ruling at whether she should be discharged at the end of the state case. That would take a matter of a day. You took almost eight months. But this is a person who wants the case to be completed. It's not the type of case that we are talking about, where there are delays wanted by people who don't want to come to court.
If I remember very well, Chief Justice, during the period of Mahere, I think I was tasked to be in the remand court. And during that time, it was the time when the then Chief Magistrate decided that all regional matters should be handled by the regional court in the regional remand. So I was dealing with a number of cases in the remand court, and most of the cases that I dealt with in the remand court, I dispensed them expeditiously. That particular matter didn't take 8 months for me to deliver the ruling. I think, if I remember well, it was only a month. And the problem in that particular matter was that
a month. It was from the 6th of July, 2022, you only delivered the judgment on the 8th of December. That can't be a month.
The ruling or
the ruling, you delivered on the 8th of December.
After 8 months?
I don't know whether 8 months. It's from the 6th of July. Calculate for yourself.
6th July to
8th of December. It can't be, you said a month or something. Can't be. Even the case of Lazarus Mchenje, you remember that?
Yes.
Yes. You remanded it 5 times. Five times, from 19 July to 13 November. Cases of Wellington Juru, you remember that?
Yes, I remember that.
Yes. Again, it's the same story. Then currently, you still have the case of Douglas Karoro. Yes. Then Andrew Masuvelele.
Yes.
You see, all that. Apart from the number of disposals, you're just not completing. Later on, disposing of the cases, your disposal rate is very low compared to most of the magistrates. One regional is completing 105 cases. From January to about May, you complete 3. Another regional magistrate is 105. You have 3. That's a bad habit, isn't it?
I agree, Chief Justice, but if you look, when I was in the regional dealing with rape matters, I was not completing 3 cases.
Thank you, Chief Justice, and good evening, Mr. Manuel. Right. When I looked at your papers, I got worried that perhaps because you have been a magistrate, it looks like through and through, except for 1 year, I think in 2002 and 2003, when you had a stint. It doesn't say for how long, but you had a stint at Gonese and Ndlovu, right? Now, then I tried to figure out whether there is anything that indicates that you have done labor law, whether at school,